Okay, I have started the recording, and I now give the floor to the Barker Ghani group to start their presentation. So I'm gonna stop sharing the screen, and I give the floor to the Barker Ghani group.
All right, thanks, Manjo. My name is Osman Ghani, and I will just share my screen now with the other people as well. Okay. All right, so I'm from the Barker Ghani group. Our topic is a visa cancellation. And we have a case here, Shane Martin versus Department of Immigration and Border Protection. I will just go to the introduction actually to my group members. Myself is Usman and Jessica, Silva, and the Ruby. So I will start from the introduction, having the factual scenario. Mr. Martin actually has been living in Australia since the age of 20 years, and he moved to Australia from New Zealand. He was born actually in New Zealand, and he was living in Australia under the category of visa subclass 444. And he used to live with his wife and his children. In March 2016, Martin was arrested under Section 501 of the Migration Act 1958 for the failure of the good character test, and he was subsequently deported back to the New Zealand. This refusal came as the Minister for Immigration exercising his personal power as outlined in Section 501 of the Migration Act 1958. It was deemed Mr. Martin must have to fail the character test defined in subsection 501 and subsection 6 of the Act. This is based on his linkage to a motorcycle gang known for its dealing with the drugs. Furthermore, Mr. Martin has been claimed that he is of Aboriginal descent. However, his claim was basically to apply for the judicial review under the Aboriginal heritage. So, my question here, number one, is that based on the circumstances of the Mr. Martin, whether he is eligible to apply for the judicial review in the Federal Court of Australia or the High Court of Australia, there are few things which department must have to be considered when they before cancelling the visa. So the decision to refuse the visa for Mr. Martin under Section 501 made by the Minister personally, and it is subject to the judicial review by the Federal Court and High Court of Australia. Under the Administrative Decision Judicial Review Act 1977, the courts are restricted to reviewing the lawfulness of the administrative decision rather than considering whether it was the correct decision. So Mr. Martin was a non-citizen. Visa was cancelled by the ministers on association grounds, association with criminal conduct, but actually on the other side he hasn't been any convicted and hasn't been charged by the police in his living life in Australia. So the department must have to consider all these factors, whether the visa holder is a genuine married, de facto or independent relationship with an Australian citizen or a permanent resident, and any hardship which would be caused to them or other immediate family members. Similarly, the extent of disruption to the visa holder's family, business, and other ties in Australia, whether the visa holders has previously been advised by the department about the conduct which brought them within the Section 501 cancellation provisions. Visa cancellation under Section 501 may result the separation between the parents and the child. Such as separation may breach the Australia's obligation under the CRC Convention on the Right of Child, according to Article 9.1 of the CRC. Similarly, Article 17.1 of the ICCPR provides that no one shall be subject to arbitrary or unlawful interference with his privacy, family, home, and correspondence. The right to respect for privacy, family, and home life is well established in international case law. Now I will move on to the question number 2, and I will pass on to the Jessica group member.
Thanks, Osman. So, basically, judicial review allows the court to assess the administrative decision on a number of different grounds. Section 501 of the Migration Act states that natural justice applies to decisions made by the minister or his delegates. So basically, they have a duty to act fairly in making any decisions. Mr. Martin is arguing that they did not, and they did not properly take into account all the aspects and evidence in relation to his visa application, as he didn't have any criminal history. The Administrative Decision Judicial Review Act outlines in Section 5 the statutory grounds for judicial review, including a breach of natural justice, improper exercise of power, and lack of evidence to justify the decision. Mr. Martin intends to apply for judicial review on multiple grounds, including lawfulness of decision, natural justice, ultra vires, and that the decision maker has gone beyond the powers granted to them by Parliament. He is seeking to have the decision to cancel his visa overturned and a written mandamus issued against the Minister for Immigration to ensure proper consideration is taken in regards to each requirement of the character test before a visa is cancelled or refused. The High Court of Australia should have jurisdiction over this matter as defined in Section 75 of the Constitution, where it states the High Court of Australia has jurisdiction on all matters in which a writ of mandamus or prohibition or injunction is sought against an officer of the Commonwealth. Just to conclude, it's stated in Green versus Daniels, 1977, that if an executive issues instructions and these are inconsistent with a proper observance of the statutory criteria, he acts unlawfully. Should his delegates then observe those instructions, their conclusions concerning an applicant's compliance with the criteria will be vitiated. I'll pass on to Ruby and Selva.
So basically, we're answering two questions here. I'll do the first half and Ruby will do the second half. So my concentration will be on the first question. Basically, for the first part of the question, it is clear though, like through my colleague's previous analysis, that the Minister for Immigration has many avenues in refusing Mr. Martin's visa. One of those being the character test. However, when considering his claim for Aboriginality, the issue became very complex. Basically, under the Migration Act 1958, the Minister has various discretional powers in relation to granting and cancelling of a visa. Mr. Martin's claim of Aboriginal descent is not a basis for which visa claims can be made when looking at the Act itself. Nowhere does it mention that this will influence a result in his visa application. It is also important to state that Mr. Martin is a New Zealand national, and therefore, having not been born in Australia, it is irrelevant that he has Aboriginal background. Further, the claim for the Aboriginal descent will not affect the Minister's decision, as it was founded on the character test in Section 501 of the Migration Act. So therefore, this claim of Aboriginal descent would not affect the legality of the Minister's decision. And just to conclude now, Ruby will be looking at the second question.
Okay, so for the second question of whether this claim would...
Ruby?
Am I unmuted? This claim would affect the outcome of judicial review. It needs to be established whether he is eligible for a judicial review. So to begin with, that is found in the Administrative Decisions Judicial Review Act 1977. From this act, it is seen that the requirements for a judicial review are outlined in Section 5 and Section 6. It is also relevant to discuss the nature of a judicial review is not to re-examine facts, and this is also considered in Minister for Immigration and Multicultural Affairs and Yusuf 2001. So, concluding the application for Aboriginal descent, it's not a legal issue, it's a factual issue, and therefore that would impact Mr. Martin's prospects for a judicial review. So concluding, thank you for listening to our presentation.
Thank you, everyone.
Thank you. I'm gonna provide some
So
feedback.
that'll be our submissions for the 3 questions. Thank you.
Thank you. Thank you to the Barker Ghani group. I'd like to give some feedback. So I'm happy with the presentation. You provided the facts quite well, and you cited some of the laws which would be crucial in determining and looking at the legality or the correctness of the administrative decision. And I noticed that you were quite prepared in having this presentation. So that's good. Now, having said that, there are some questions I would like to ask, unless there is anyone else in the class who would first like to ask some questions. None? Okay, so let's begin with the fun part. I'm getting confused here. On the one hand, wait, is that Ruby? Her image seems to have frozen. Is that correct? Or is it my screen that's acting up?
No, my one is freezing too every now and then. So.
Okay. Yep. Okay. So let me just clarify. I'm getting confused there. I think I heard one of you saying that judicial review was available to examine the case of Mr. Martin, and then I think it was Ruby who then talked about the inadvisability of undertaking judicial review. Okay, so the first question I'd like to ask is, if you were to suggest judicial review as the appropriate remedy to review the administrative decision regarding Mr. Martin, what is the basis for the judicial review? You did cite natural justice, but why is natural justice relevant in this case?
I'll start, sorry. Okay. I think so. He has been living in Australia on a long term. That's one reason, and his family is living, and his 2 sons. One of them actually is a good player and is doing really good things for the Australia. And the other son has been fighting in the Australian army. So, and other thing is that he never had been convicted and never had been charged to the police or with the police and on any wrongdoing act. So based on all these background scenario, department must have to consider or should have considered before, well now they have cancelled the visa further, but having the prepared application for the judicial review. So based on all these things, he would be able to access to the judicial review because he has been doing all the way to the right things.
My question is, what is your factual basis for alleging that there has been a breach of natural justice? That part is not clear to me. Where is the breach of natural justice?
Well, because how should I explain? Minister has a power to cancel the visa, and if he suspect, and he has to, if he suspect, and if no one is doing something wrong, and he hasn't been proved he has done something wrong, so minister definitely has a power. He can cancel anyone's visa. He can cancel anyone's, if you want to grant someone, if you want to cancel someone's, but it has to be somewhere legitimate. It has to be somewhere like or he has been proved he has done something wrong. For example, there are few visas has been cancelled because the applicant has been in the sentence or in the detention center for 12 months or for a year or even in the jail. So it's mean there's a conviction, but this guy hasn't been convicted for anything. So the minister has the power and he's cancelled. So his power has to be looked by a court whether he's acting properly, things like that.
But let me clarify. The principle of natural justice is a common law right. And given that it is a common law right, it can be displaced by statute, by a legislative enactment. And if I'm not mistaken, the Immigration Act actually provides specifically that the principles of natural justice do not apply in relation to deportation cases. And the reason behind that, as far as the Parliament is concerned, is because it's not clear that any person who is about to be deported really has the right to be heard, because to a great extent it is a discretionary. It lies within the discretion of the state of Australia to allow people to stay or not. So if I'm not mistaken, therefore, and I could be wrong, the Immigration Act specifically provides that the principles of natural justice does not apply. What exactly is the law on the subject? So there are two aspects now. One is I was asking about the factual background for the claim that there was a breach of natural justice. So far, I'm not convinced that that has been answered. Assuming that there have been certain facts which can suggest that there might have been a breach of natural justice, the other question I ask really relates to what the statute contains. Because as I said, if I'm not mistaken, the Immigration Act provides that the principles of natural justice do not apply in relation to deportation cases. So can you enlighten me on those 2 points, at least on the last point?
I'm not really sure how I can answer with that, but again, as I said before, according to the natural justice, he has been going away from his family as well, and he has done all the right things for the country. And it's again a story of loss. I don't know how to, if I can get any other group members to jump into that and see what their thoughts.
Yeah, what do the other group members say?
Basically, what I believe is there was a case just yesterday. 1 second, I'm just opening it up to. Hold on. It was similar facts in regards to and they didn't look at they got satisfied the discretion in section 501 of the Migration Act to refuse permanent on character grounds.
Okay, my suggestion to the group, because you're obviously going, okay, from Lauren. Lauren, let me just check what Lauren has said here. Okay, so according to Lauren, thank you, Lauren, section 134A, the rules of natural justice do not apply to a decision made under the subdivision. So, I mean, it could be possible that the decision was made on the basis of some other subdivision of the Act. But to the group, because you will need to work on your individual research essay, you have to be very careful about claims of a breach of natural justice, because natural justice is a common law right, and it can be displaced by either the express or implied intention of the Commonwealth Parliament. Okay, so have a look. You need to go back to the statute. Regarding when it comes to emergency cancellation on security grounds, I suspect that in other subdivisions of the Act, there are other provisions there which provide that natural justice does not apply.
Yeah, sorry, I obviously can't copy and paste all of them.
Thank you, Lauren. Thank you, Lauren. That was helpful. I just wanted to flag the group's attention to the fact that natural justice can be displaced by.
That was just to give you guys one example, I guess, from the Migration Act, where you've said, Manjo, that natural justice may be displaced. So that's just briefly opening the Act without going through it all to give any other examples.
Thank you very much, Lauren. Thank you. So now, have a look at that. Now, there is another question I asked. What perplexes me is, why is the group focusing on judicial review as a remedy, assuming that there was a breach of natural justice? And it could be because he wasn't given the right to be heard, when in fact the law should have, under the law, Mr. Martin should have been given the right to be heard. And I don't really know that, because as I said, that does not seem to be what the Immigration Act provides. But assuming that Mr. Martin had a right to natural justice and that right had been breached, my question is, why is the group focusing on judicial review? And why not an application for review to the Administrative Appeals Tribunal? That's what I don't understand.
What I have comes from that, because this visa was cancelled by the minister personally, and if the visa cancelled by the personal minister under his personal power, this what you call the case cannot be reviewed in the AAT.
Why not?
And sorry, just to chime in, from the actual article that we got this story from, it states in there as well that they're actually seeking a judicial review for the case.
I mean, that's fine, but my question still hasn't been answered. Why shouldn't he apply for a merits review by the Administrative Appeals Tribunal? Because it has a refugee division there. Why go for judicial review?
But as far as I understand, it's again, like it's in the Act. So the visas cancelled under the minister personal power cannot be reviewed by AAT at all. So it's only a review, judicial review.
That's odd, because again, when an executive typically exercises his discretion, what we call, the minister acting in using his discretionary powers, we will recall that it is in fact the nature of merits review to examine the correctness or preferableness of an administrative decision. When it comes to whether or not a decision is preferable or not, that exactly examines the exercise of discretion by an executive. So typically, when you speak of administrative law, it is in fact within the purview of an administrative tribunal to examine the exercise of discretion. On the other hand, it is not within the scope of judicial review to examine the exercise of discretion. So that makes it really more confusing now, because what you're suggesting is that when an executive exercises discretion, then that is subject to judicial review. That is in fact an incorrect statement of the law, because judges can only examine the legality of a decision, and they certainly don't have the power to examine the correctness in the exercise of discretion.
But as I stated, we were following as well what the article said about them seeking a judicial review.
When you say article, you're talking of a news story?
That's correct. That's where we got the story from.
Yeah, you shouldn't. So the story provides the factual background.
And the factual background, they are seeking a judicial review.
Yeah. So, but in relation to the individual research essay, thinking like a possible solicitor of Mr. Martin, you need to.
Yes, definitely. You can discuss whether or not to go for what would be the merit review or a judicial review, what the benefits are. As I said, we were sort of focusing on what the actual factual issue was that was provided, and they were going for a judicial review. So,
okay, I'm happy with that. So, with that, would there be any other questions from the class? No? Okay. So, thank you very much, the Barker Ghani group. You presented really well, and I know that in a sense, I asked a few questions which made you think. And I'm hoping that you'd think about my questions in relation to the individual research essay. So thank you.
Thank you so much, Manjo.
Thank you.
Thank you.
We have another group actually presenting tonight. And I think the problem really was the fact that the Fantastic Four is actually based in Sydney. And it means that they're 1 hour ahead? Or are they 1 hour behind? I think they're probably 1 hour ahead. But I have a message here from Dominique that they are prepared to present. Dominique, can you confirm that Oh, it's 7:30 there. Okay. So you should have joined us earlier. Dominique, are you prepared to present tonight? Okay, good. So can I give the floor now to the Fantastic Four, who will then do their presentation?
Hello, can you hear me?
Yes.
This is Mitchell Sullivan speaking. How are you? I'll start off with an introduction. John Edwards is an English citizen studying Bachelor of Laws at CQ, Central Queensland University. He was granted a student visa in 2015. In July 2016, John was involved in a serious altercation with a fellow member from his cohort, Peter, resulting in a conviction of grievous bodily harm being recorded. A court order of restitution was placed to pay any and all medical expenses acquired by Peter, along with mandatory community service amounting to 20 hours. As John and Peter were both members of the same university, soon enough a second altercation erupted. This time was only a verbal confrontation, but John, fed up with the situation, accompanied by the fact that he was feeling wrongly convicted, took it upon himself to change universities in an attempt to remove himself from further issues. November 2016, John was contacted by the Australian Immigration Department to notify him that the decision was made to cancel his visa on 2 grounds. Firstly, Section 104 of the Migration Act, if and when circumstances change, one must notify an officer of the Australian Immigration Department as soon as practical. And secondly, Section 116 of the Migration Act confers that the Minister may cancel a visa if he or she is satisfied that the presence of its holder may or would be a risk to the health, safety of an individuals, or the good order of the Australian community. John feels as though the cancellation is wrong and is unfair to his situation surrounding events. John is hoping to have this decision reviewed. On to question 1 from one of my group members.
So question 1, I have the slideshow as well. Am I able to share the screen?
You could actually share that. Are you familiar,
Yeah.
Dominique, on how to do that? So there is
Yeah.
a screen icon at the bottom of the screen.
Is that sharing?
Yes.
Yeah. Okay. So that was the factual. Question 1, does John have a substantial basis for judicial review? What are the administrative law elements needed? Under the Administrative Decisions Judicial Review Act 1977 of the Commonwealth, the test to determine whether the decision is fit for judicial review, it must first establish 4 elements. There must be a decision. The decision must be of an administrative character. The decision must be made under an enactment defined in Section 3(1), and the decision must not be an excluded decision. Administrative decisions are only reviewed if they are this word's hard.
Justiciable.
Justiciable, yes. It's hard to get out. And in accordance with the law, a judicial review is to ensure a decision has been made with correct legal reasoning and has followed correct legal procedures. The court can only examine how the decision was made. In other requirements John would need to meet for judicial review to be available include jurisdiction of the court to deal with the application for judicial review, justiciability of the dispute, standing of the applicant, a ground for review of the basis of legal error or unlawfulness of the decision, and remedies sought must be made out. As a rule, judicial power is restricted to actual controversies involving rights to the life to the rights to life, liberty, or property. In John's case, there is a substantive matter which in dispute is the legality of the decision made. It is an actual controversy that in turn has become a violation of rights which affects his life and liberty. And then we've got question 2. which is what are the administrative law legal remedies available to John? The second question explores the issue of executive accountability. The aim of this principle is to ensure that the Department of Immigration can be called to explain and to justify the way in which they have gone about their task. The legal remedies available are internal merits review by the department itself, merits review by the AAT, and statutory judicial review. In John's case, it had been established that the legislation entitles John to a review by the Administrative Appeals Tribunal of the Minister's decision under Section 306 of the Migration Act 1958, Commonwealth. John changed course without notifying the Immigration Department. This is grounds for visa cancellation under Section 104 of the Migration Act. This alone could trigger the justifiability cancellation of his visa. John also failed a character test due to his conviction involving violence against another person. There are no specific requirements as to how this character test should take place. The type of decision which has been made is very much that of cause and effect. However, it has been revealed that there are extenuating circumstances surrounding John's actions. Another option available to the AAT is a merits review consisting of a hearing de novo. In conducting a hearing de novo, the AAT is not limited to the evidence that was before the Minister for Immigration. The AAT can decide matters based on all the circumstances surrounding John's actions. Further, the AAT would not be limited to the reasons considered in the original decision. And then I think Mitch.
Yep.
Back to you.
Yep, that's me, sorry, thank you. Question 3 is to discuss and explain the difference between how merits review and judicial review would consider the approaches to John's issues. So firstly, merits review. The Administrative Appeals Tribunal, or AAT, must have jurisdiction expressly conferred upon it by the legislation. There is no automatic right to an appeal to a tribunal. Hence, Section 306 of the Migration Act makes special mention that application may be made to the Administrative Appeals Tribunal for the review of the decision. This is also reinforced by Section 25 1A and B of the AAT Act for the review of merits. Merits review in its proper sense is more than the mere reconsideration of facts. That merits review bodies whose powers are usually tailored to the identification and assessment of evidence are highly suited to the fact-finding as well. A de novo hearing is a rehearing of the entire case, including review of all material examined by the original decision maker, as well as having any new evidence that may come to light. Merits review usually includes a de novo hearing and for the reconsideration of existing evidence, and fresh evidence, whilst also exercising any of the powers of the original decision maker. In this instance, a review of the decision of terminating John Edwards' student visa made by the Australian Immigration Department. This review will take into consideration external and relevant factors. These include the reasoning behind why he was why he changed universities, his lack of notification to an officer of the Immigration Department and why, but also the surrounding facts regarding the charge of grievous bodily harm. A merits review body makes decisions within the same legal legislative framework as a primary decision maker and may exercise all the powers and discretions conferred upon that primary decision maker. The AAT has the power under Section 43 of the AAT to affirm but not change the primary decision, vary the primary decision, set aside the primary decision and substitute for a new decision, remit or return a matter to the Department of Immigration for reconsideration with specific directions. Secondly, judicial review. Administrative Decisions Judicial Review Act 1977, Section 5, confers that for review of decision, a person must be aggrieved by a decision to which they may apply to the Federal Court or the Federal Circuit Court for an order of review in respect to the decision. The reference to natural justice relating to audi alteram partem, or a right to a fair hearing, which Mr. John Edwards did not receive before the Australian Department of Immigration decided to terminate his student visa. Judicial review seeks out legality of the decision, not the merits. In this instance, the judicial review of the Australian Immigration Department found that its decision expressly conferred by the Migration Act 1958, acted within the constitution of the enactment and by not over-encroaching the limitations.
So can you wrap it up in a minute?
Yeah, no worries. Brendan J. stated in the case of Church of Scientology v. Wood, the judicial review is neither more nor less than that the enforcement of the rule of law. It is the means by which executive action is prevented from exceeding the powers and functions assigned to the executive by law and interests in individuals protected accordingly. I'll skip a little bit. No, that's fine. Just leave it there. I'm happy to wrap it up if you are.
Thank you. Okay, so thanks for the presentation. I'd like to provide some comments. It would always be nice if you have a presentation that you're able to use a PowerPoint slide. So I saw that eventually you did have a PowerPoint slide. It came up, but when Mitchell first started the presentation, there was nothing. It's helpful to provide, to make use of PowerPoint slides, because especially if you just use bullet points or key ideas, it does help the readers or the listeners focus on what you're saying. So try to do that next time if you have a PowerPoint.
That was my fault, sorry. I didn't jump in time.
That's right. So that was the second aspect of the observation, Dominique. The use of the PowerPoint slides wasn't synchronized with what Mitchell, for example, was saying. So he was reading something, but the PowerPoint slides were not there. So you need to work on the synchronization. Otherwise, it can get difficult for the presenter as well as for the listeners. The other thing that you need to remember is that when you have a PowerPoint slide presentation, avoid reading off the slide. Okay, so if you have something on the slide, they should, the content there should only refer to key points. You should not be reading off the PowerPoint slides, mainly because as far as the listeners are concerned, there is what is known as cognitive overload. It's difficult to be listening to somebody while at the same time reading text on the screen. So what is on the screen, which is being used by the presenter, for example, is only used as some kind of a prompt, as a way of assisting the presenter to present ideas, but the presenter should avoid reading what is on the slide. Okay, yeah. So in future, those would be my comments. But in general, it was a good presentation because it was quite thorough. So it was quite clear to me what the factual background was, as well as what the relevant laws were. So having said that, would anyone from the class have any questions or comments to the group? None? Okay, before I ask my own questions, can I just ask if there is any other group that is prepared to present tonight? Because at the start of the session, I had asked if the Brisbane group, the Gladstone group, the Swalan Diego group, as well as the Drakes, or even the Legally Blondes, were prepared to present tonight. Is anyone from any of these groups available tonight in this tutorial? Is any other group prepared to present tonight? No? Okay. I wonder what happened to them. Okay, so let me just ask some questions here. So at the start, the group talked about justiciability. And I'm not sure if justiciability as a concept was properly used in the presentation. How did you understand justiciability here? And why is the principle of justiciability even relevant to the factual background? So let me begin by answering, how did you understand, or how do you understand justiciability? And what does justiciability have to do with the factual background? Let's begin with that.
Manjo, can you hear me?
I could.
Yeah, Manjo, I think...
Is that Mitchell?
It's Michael, sorry, yeah, Michael.
Yes. Go ahead, Michael.
Yeah, I think we brought up the idea of justiciability to kind of generate the conversation between looking at a case based on justiciability and looking at a case based on whether there'd been a decision made which we could take to the AAT to try and see if we could find a solution with the AAT, as opposed to whether it was an issue with justiciability.
Okay.
That was part of it. Yeah, so that was part of question 2, is comparing one to the other and trying to decide whether one would be more appropriate.
Which brings me to my question: how did you understand the concept of justiciability, and what is its relevance to the factual background?
Well, I understand it to be the law based on the correct decision legally based on the law, and in this case, I don't think there's any question that the minister made a correct and justiciable decision to cancel the visa. The question is whether he actually made a preferable decision, which I think we could.
I see what you mean.
With the merits, with the AAT.
Okay. Justiciability actually has a more defined meaning, both in constitutional law and administrative law. And justiciability as a principle means that the question that is before a Commonwealth court or a federal court is one that is justiciable by the court. And when we speak of justiciable, therefore, there are two things that we need to remember. One is that courts will refrain from entertaining a question if it is in fact a political question. So in other words, if the question relates to whether or not a decision is something that could properly be made by the legislature as the elected members of the Commonwealth. Where's that noise coming from? Hearing some background noise. I'm going to mute everyone. Okay. Where's that noise coming from? Okay, there. Okay, so let me repeat. So justiciability has a more precise meaning, both in constitutional law and administrative law. When we speak of justiciability, it means that it involves properly a legal question instead of a political question. So a political question is one, such as, for example, should abortion be allowed? Should it be permissible to allow children below the age of 10 to be incarcerated? Should it be permissible to force the sterilization of those who might have very diminished capacities, mental capacities? Now, those do not involve legal questions. They are what are known as political questions because they are best addressed and determined or decided by those who are elected representatives of the Commonwealth. So in that case, the court will say that that is a non-justiciable question, saying that's actually a shorthand for saying that that is a question that is not for the courts to decide, but actually for the elected members of the Commonwealth, meaning the legislature, to decide. So that is the notion of justiciability. In other words, it does not involve a legal question. It involves a political question. So the other aspect of justiciability simply means that as far as the court is concerned, when it makes a decision, the question is, can it use legal standards in order to determine whether a decision is lawful or not? And the problem with political questions is that the standards for the purpose of deciding whether or not a decision is legal or not is not really a legal standard, because as we said, whether or not euthanasia should be permitted, it doesn't involve a legal standard. It involves more a political standard. It can also mean that that is a policy decision that is best left to the executive or the legislature to make. So I'm just flagging that because I felt that the use of the word justiciability was loosely used in the facts. Okay. Any questions on that point? None? Okay. So my second question is, if you were the solicitors in this case, would you have advised that the applicant or your client seek a review via a judicial review or a merits review by the AAT, and why?
Hello, Manjo, it's Mitch here.
Yes.
I would personally recommend merits review.
Mm-hmm.
And the reason I would recommend that is to take into consideration the surrounding events. The fact that the charge of assault was essentially not his fault; it was just an altercation with a member of his cohort. And secondly, the reason he didn't change, the reason he changed universities in the first place is because of the altercation, and take into consideration the stressful surroundings and environment that he was in leading up to when he changed his circumstances. So essentially with judicial review, I believe that the Minister for Immigration was within his boundaries. He used the legislation to his power and made a decision, whilst I think that judicial review would not have the result he would want, while merit review he probably has a better chance of getting, a fair hearing and also a better result.
Oh, that's a very persuasive answer. Let me just clarify some facts, because it would appear to me that there were at least two grounds by which the decision was reached to cancel the visa. One was because of a change of circumstances. Was that in relation to the fact that he changed residences without informing immigration, or was it because there seemed to have been a kind of a conviction or the criminal offense that was committed?
Probably on both grounds. Essentially that he had the criminal charge laid against him, but also just I'm not sure the exact section that it's in, but it pretty much, in a nutshell, it's any information whatsoever that's changed on the application for a visa. You have to notify an officer of the immigration department as soon as practical or practicable.
Okay.
That's any question to my knowledge. I'm not sure the specifics of it.
Okay. So thank you for that, Michelle, and thank you to the group, Michael, and so on. So I'm happy to stop asking questions now. Would there be any other questions or comments from the class before we end tonight's session, unless there is a group that is actually ready to present tonight still? Questions, comments, suggestions to the group, feedback? None? Okay, then. So I guess we could end tonight's tutorial. And I thank the two groups for presenting tonight. I think you both did really well.
Manjo?
Yes, Lauren.
Sorry.
Yes.
Could I just make one minor possible suggestion? Maybe, I don't know if it's worthwhile emailing the cohort or putting something on Moodle just to confirm who's presenting next week, so that everyone's clear of who should be here, so that there's no confusion.
Right. I should have thought about that. Yes, I agree with you, Lauren. Thanks. I'll do that. Okay. So with that suggestion of Lauren, thank you, Lauren, for that. I hope to see you again next week. And to the two groups, you did well. Thanks. So good night, everyone, and I'll see you again next week. Bye.